Well, my good friend Dr. Stuart Ambler pointed out to me that I was in error saying that there was justice before the Johnson Nixon administration or era. And he is entirely right. But that wasn't the point I was trying to make. The point I was trying to make is the fact that after that, there were substantial changes that lessened the chances of justice with the abolition of some jurors' rights. So, as I stated in the past lecture, the jury nullification idea started with, or came to light with, the trial of William Penn. He was prosecuted for practicing the Quaker religion, and the Crown prosecuted him, and the jury acquitted him. And that was traditional throughout the centuries following that. In fact, Pennsylvania has a specific statute for that. Now, what I meant by the change to Napoleonic Code was that under Napoleonic Code, there is no concept of precedent as there is in Anglo-Saxon common law. In common law, you have to follow the precedents set by previous courts unless there's some good reason not to. But most governments, after a while, get despotic. And democracy, or participatory government are mutually exclusive at many times. So efficiency leads to one result. Democratic participation may or may not lead to a different one. The question is, which one is more fair? Well, I think every public interest group needs a good dictator in order to get things done, or a ramrod or whatever. Corporations work effectively and efficiently that way, but because they don't have courts looking up their asses all the time, and the legislative bodies are generally the directors, which are handpicked by the by management of the corporation, or the financiers like the banks. But back to the point. From the time of William Penn throughout the time of our colonial history, the jurors were looked upon to sort of examine both the facts of a case and the fairness. So where it really came to bear was in the Prohibition era. In Prohibition, a group of unhappy people were afraid of immigrants, afraid particularly of Irish immigrants, and because of their fear, they knew that many of these people drank a lot. Many of them got off the boat in New York and stayed in New York City, and many of them were the subject or became the subjects of Tammany Hall, which was a democratic machine run by bartenders, etc. So in order to break up the stranglehold of the democratic machine on politics, particularly the democratic organization of politics and the redistribution of wealth and other things that the capitalists were very, very afraid of, prohibition became a weapon used to at least go along with the saying, no Irish need apply, etc. Now, a lot of people thought the prohibition law was stupid, silly, or whatever. You had the temperance union people that were really fanatical, but there was a big difference of opinion whether that should be criminal or not. It was probably bad enough when they tore up the stills and busted up the bottles and the casks. When they started putting people in jail for it, that was probably a little bit too much. So juries stopped convicting. Now we go on a little later, and there's some other legislation where juries wouldn't go along with it. And I myself, when I started doing civil rights cases and draft cases, I used to win many, many jury trials by arguing that it wasn't fair. This was particularly effective in draft cases because I would try to put the war on trial. And the government was vulnerable there because there was no declaration of war. So the Constitution provides for declaration of war. They abdicated to the legislature and to some of the committees there. And it was a real questionable action jailing people, and particularly in some of the draft dodging cases. I remember sitting in, I think I said this last time, in one judge's chambers when a warden called and said, quit sending us these people. They're bright and they're raising hell in our institutions and organizing our prisoners. In any event, with Prohibition came a big movement to limit the power of juries to say bullshit. And this is one of the functions that was laid down by Wigmore and other people clear back to the days of William Penn, that you had despots, and one of the best ways to handle despots was to let a jury have the ability to judge both the action and the intent, consequences, and fairness of the legislation, rules, etc. Now, Stuart was perfectly right. Before this, we had Jim Crow laws, we had discrimination, we had Klan activity, things such as that. But we still had some semblance of fairness. For instance, the Scope trial, teaching evolution, it happened in Tennessee. And William Jennings Bryan and Clarence Darrow faced off against each other. They were putting Mr. Scopes under prosecution for teaching evolution as a subject matter. And the Bible thumpers there thought this was wrong because the Bible said there's no such thing. And they were fundamental in their beliefs and tried to enact their beliefs into a criminal law, making it illegal for a teacher to teach evolution. There's other examples that Darrow used in his arguments. A lot of the cases in Colorado, there's one particular case that happened to a friend of mine. She was sitting on a jury in a drug case, and it was in Jefferson County, District Attorney's Office, Gilpin County. And they've always been very zealous in their prosecution. I remember one case they tried to prosecute involving a college professor that I'd represented, whose child had died falling from a swing set, and he admitted to having LSD in his dresser drawer, which had nothing to do with the kid falling off the swing set, getting a concussion, etc., and dying, which was very traumatic for the family, by the way. And they indicted him under the felony murder doctrine, on the basis that he was committing a felony while possessing PhD or possessing LSD, even though he had a PhD, and that since it was a felony to possess it, and it was an ongoing felony if somebody died while he was committing the felony, namely his child, then he was guilty of the felony of murder, because a felony committed while a felony exists is another felony. So he split, and I spent the time fighting extradition here. But the DA in Jefferson County was very eager to extradite him back to Texas. But this was before a fellow named Timothy Leary challenged the Texas court and Texas drug laws, and resulting in the famous case of Larry versus Texas. But going back to the nullification, my friend Linda Creel sat on this jury and argued to the jury that the defendant shouldn't be convicted of the crime of which he was accused. So the judge, Judge Barnhill in Jefferson County, called a mistrial. And the prosecutor then indicted the juror for not following the rules and engaging in jury nullification, and essentially not doing what the judge told her to do, which was entirely against at least 4 centuries of precedent that I know of. But that's what happened. The judge reads a statute, says the statute says this, well, the statute says this, I've got to do that, and we'll indict. Well, this is not common law. This is Nappoleonic code. Napoleonic judges are not bound by precedent. They can interpret the law the way they want. And they really don't have jurors. They have inquisitions, and occasionally they have inquisitorial panels, 3-judge panels. But essentially, they determine what the law is, and they apply the law, and that's the way things are under the Napoleonic Code. And with the Nixon administration, that was the type of law that we were enacting in the United States. They were abolishing precedent, and they succeeded. Actually, I think I mentioned one clerk that worked for me right after law school told me that he clerked for the Supreme Court before working for me, and was told, don't pay any attention to any cases that are older than 5 years. Well, the precedent in law is much more than 5 years old. I study medieval law. I've been to places where I've read the decrees of Charlemagne, written in Latin. I did that at Rothenburg in Germany. I've read a lot of the English cases. I have a whole line of ancestors that were trained in Lincoln's Inn in London as barristers. And you're trained in the tradition of law and the common law. I also had training in equity, which was another ecclesiastic area. And lawyers nowadays don't seem to have the historical basis. They're really pragmatic. A lot of them don't give a damn about the history of the law or how it should affect people, because all they care about is the billable hours and servicing the client. So we've got instances where you get a guy like you now at the University of California, who is, while with the Justice Department, was told to write a memo justifying torture. And there was a statute. He didn't want to be bothered with precedent or anything like that, the idea of war crimes or whatever. And he wrote a memo called the U memo, and it said it's okay to torture people whenever you're in an ideological war or whatever, like the anti-terrorism was. So that is one of the problems of not allowing nullification. You can have a group of elitists pass a bunch of laws and then say, well, the public, the great masses, the unwashed, or whatever the hell you want to call them, can't do anything about it. So if we say that, for instance, the rich don't have to pay more than 10% for taxes on their income, and no tax on the income earned by their investments, whereas the peasantry has to pay 30% tax, and maybe the peasantry decides that isn't fair, and you prosecute a tax protester, and the tax protester says, well, that isn't fair, and the judge says, well, it doesn't matter whether it's fair or not. That's the law, and the rich people make up the law. So convict this poor peasant for not paying his taxes, even though it might cause hardship to his family or to himself, because that's the law, and the law is the law. We had all kinds of examples of that during the Vietnam days and the civil rights days, the protest movements, for instance. I can remember doing protests at the bomb factory on Rocky Flats. Boulder, where I live, made nuclear weaponry 10 miles out of town. And it was very unsafe there. They had a few accidents, and the public was kind of nervous. But on their property right before there was a big sign put up by the people that were in power at that time saying, "Impeach or Warren." And right next to it was another sign that said, "Get the U.S. out of the red UN." So you can see it was an ultra-conservative. They were pro-weapon, they were pro-nuclear, and the public be damned, because a lot of them lived in Washington or elsewhere, and they weren't as concerned, and they were more concerned about making weapons to keep the Russians at bay so that the Russians wouldn't do like they did with the Tsar's family and kill all the rulers. Anyway, that was the reality of Boulder at that time. And when the protests started, they started arresting and charging them with trespass. And those of us in the Lawyers Guild that represented those cases used lesser of two evils as a defense and other tactics in which to tell the jury, you don't really have to defend. There's no reason that you have to convict. Is this a fair result? Is this a just result or not? If it's not a just result, then don't convict him. And we would win. And after a while, the district attorney's office in that jurisdiction said that we could have our one trial and pick a case and get the publicity that nuclear weapons were bad and dangerous, etc. And as a result, there was enough pressure to eventually have closed down the nuclear plant at Rocky Flats. And this worked really well for a number of years until some nuns went to a missile silo near Fort Collins, between Fort Collins and Boulder. And they broke into the missile silo as a protest against nuclear armament and missiles and things like that, trying to draw attention to the nuclear arms race. Well, the Bush administration and the prosecutor appointed by the Bush administration decided, because of the Iraq-Iran situation and the Pakistani situation and the Afghani situation, that he wasn't going to allow any bad press or any challenge to his executive authority to declare war without the permission of Congress and send troops to invade foreign countries. So they negated treaties worked out between various law groups and the prosecutor's office and prosecuted some nuns for going on the missile site, which I think was decommissioned, but I'm not real certain at this time. And they took hammers and banged on the railroad tracks and threw blood on the railroad tracks. And they were charged with sabotage and all kinds of heinous crimes under the Defense Acts. They had jury trials. And a really good friend of mine, Walter Darash, was the attorney that represented them. And the jury convicted because any idea of nullification was denied. Now, my office ended up with the appeal, but it was a horrid situation because there wasn't any concept of justice. The administration had declared, we want war in Iran. We want to invade Iraq or whatever. We want to invade Afghanistan. Like it or lump it, but we're going to do it. And if you protest, we're going to screw with you. We're going to stop you. We're going to punish you. Screw this free speech thing. It interferes with our policy. And that's what they did. They came down heavy-handed on these nuns. And I was shocked, and it really devastated Walter that the juries convicted him. And there are a few interesting things that happened in there. For instance, we filed a motion to reduce bail or grant a public relation or personal recognizance bond, and the prosecutor objected, and they said they could bond out. All they had to do is sign an agreement that they wouldn't break any state, federal, or local laws. And the nuns said, it is our job, it is our duty, it's part of our religion to point out unjust, unfair laws. And we're not going to be admitted to bond and sign a pledge that we won't still be activists against unfair and unjust laws. So they sat in jail until their trial. Now, the fact that the prosecutor would object to a public relation or a personal recognizance bond under those circumstances, I thought was a clear violation of the right to assembly, the right to redress the government for grievances, and all the other First Amendment rights that generally were contemplated by the drafters of the Constitution. But the Bush administration didn't give a shit. They were right, and they manufactured the law for the war. They manufactured evidence against Iraq with the aluminum tubes. They tried to destroy a CIA agent named Valerie Plame. They did all kinds of things, between Condoleezza Rice lying to the public and all of these things. And here, when they prosecuted the nuns, none of us were able to really get the legitimacy of that war into issue because the courts wouldn't let it due to the rulings against jury nullification. Now, there was a fine. They gave jail time to the nuns and fined them. And they wouldn't be released because they refused to pay the fine, because it funded the activity that they were against ideologically. So they did have a fundraising thing where they raised the equivalent of food and gave it to a local Air Force base, but the judge was limited that. So what we had is a situation where a war was declared under fraudulent circumstances. The movement of the government moving troops and invading a foreign sovereign nation to have a regime change was probably illegal under international law. And you couldn't really bring anything about because the judiciary was locked up by legislation saying they couldn't allow that. Did the person do the act? And if the person did the act, then he's guilty. Did Jean Valjean break the window of the bake shop and grab a loaf of bread? Yes or no? If he did, he's guilty. If he didn't, then he's not guilty. It doesn't matter whether he was doing it for his own benefit, whether he wanted to permanently deprive others of that bread, or whether he did it out of necessity to feed his family, as kind of existed under Judeo-Christian doctrine for centuries. That just doesn't matter under Napoleonic rule. And that's what I meant by our system changing from a common law, ecclesiastic-based system into a Napoleonic Roman-based system. Remember, the Roman law was the law of occupation, not the law of consensus. Under that, power came from the top down rather than from the bottom up. And if we want to maintain the power of the people, we've got to do something about the changing of the law basis based on Napoleonic code, which is highly efficient, rather than democratic doctrine. Thank you for letting me explain this. You guys have a good day. Hope to see you soon when the quarantine gets broken. Until then, stay healthy.